centre has given its reply on the Supreme Court's suggestion of giving a pause to the sedition law, even as the centre looks into aspects of it. The centre has said that, as a compromise, has said that an SP level and above officer can file a sedition FIR. That can't be filed by just any cop lower rung. It has to be filed by an SP level cop and above any complaint regarding the sedition law. The centre has said that we can't pause the sedition law based on PIL, and that courts should decide on pending cases regarding sedition, as there are several cases connected to sedition that are currently in the courts, and the petitioners have opposed the government's proposal. They want a stay on it. Kapil Sibal, who's arguing for one of those who's filed the PIL, said cannot leave it to the courts to intervene. So there you have the centre's stand on keeping the pending sedition cases in abeyance. The Supreme Court had suggested this to protect interests of citizens already booked and not to register any fresh cases on the sedition under the sedition law till the government's re-examination of this colonial era penal law is over. However, the centre, which was to reply today, has said that they cannot pause it just based on PILs, but have said that what they can do is that only SP level and above, a superintendent of police level and above, can file a sedition FIR and can't pause, and also said can't pause the sedition law based on PILs, and the courts should decide on pending cases. However, the petitioners in the case have opposed this, and Kapil Sibal, who is arguing the case for one of the petitioners, there are several petitions, remember, and they've all been clubbed together. Kapil Sibal has said cannot leave it to the courts to intervene every time a sedition complaint is being brought against somebody. The top court was to decide whether a 3 or 5 judge bench should hear the batch of pleas challenging the validity of the sedition law, and it was the government that took a new stand, saying they will re-examine and reconsider the sedition law by an appropriate forum. So that was the big news earlier in this case, where the centre took a change of stand and it defended the law, but also said that they would re-examine and reconsider the sedition law by an appropriate forum, and also urged the Supreme Court not to invest time in examining its validity once again. However, the Supreme Court had then asked the centre on whether, till the centre decides on the sedition law, whether it should be paused, that all the pending cases across the country, they should be put in abeyance. However, the centre today replying, saying can't pause the sedition law based on a PIL, also putting the onus on the court, saying that, the courts should decide on pending sedition cases, and saying that SP level and above can file sedition FIR. Well, let's go across to NDTV's Arvind now for more. So, Arvind, today the centre replying to the Supreme Court suggestion that the sedition law be put on pause, that those who are facing sedition cases across the country, that it be put in abeyance. However, the centre not agreeing to this, saying that it can't be done just based on these PILs, and also saying that what they can do, however, is that an SP level or above officer can file a sedition FIR.
Yeah, Gargi, centre has submitted before the Supreme Court saying that there can be another added level of scrutiny in registration of cases under Section 124A of IPC, that is sedition law. So what the centre is proposing to the Supreme Court is that they can ensure that any case that is to be registered under sedition law should be registered only by the SP level officer. Only if it is cleared by the SP level officer, only then sedition law can be invoked, or sedition and accused can be booked under sedition law. So that's the proposal of the Supreme Court. But whereas the petitioners are very clear that they want a stay on this particular sedition law. In fact, Sibal, who is appearing for the petitioners, he has gone to an extent saying that this particular sedition law should be struck down, and that's why he is saying that there should not be any more cases registered under sedition law anywhere in the country. Now, Supreme Court is, judges are discussing among themselves. In fact, Supreme Court told both the parties, both the centre and also petitioners, saying that they are not hearing the case on merits today because that will take a longer hearing. But today, the Supreme Court is looking for an interim arrangement, because centre has told the Supreme Court that they themselves are reviewing or reconsidering the need of sedition law, that is 124A of the IPC. So in that case, if the centre is reviewing it, what should be the interim arrangement is something the Supreme Court is discussing. We'll get to know an interim order from the Supreme Court anytime now.
All right, Arvind, thanks so much for joining us. With that, let's go across to Sukirti now. And Sukirti, tell us what happened in court. All right, let's go across to Sukirti, who's on the phone line with us. Sukirti, so give us more details about the centre's reply in the Supreme Court today.
Firstly, the centre is opposing any kind of stay on the law in entirety. What it is proposing, on the other hand, as an interregnum period solution, is what they are saying is if any future FIRs to be registered, the scrutiny for that should be done by a SP level official, which is a superintendent of police, or an official over that level. And as far as pending cases are registered, there may be many lodged across the country, many of whom may involve additional charges of terrorism, etc. as well. So regarding that, it is hard for the centre to take a clear stand on that as of now, because they don't know what these additional charges would involve. But what they can suggest as a solution for pending cases is that if anywhere bail applications are being put in terms of these cases, then the Supreme Court should pass a directive that all of the bail applications in sedition matters should be heard on an expeditious level. The petitioners, who are being represented by senior advocate Kapil Sibal, have been opposing the centre stand. What they are saying, initially they said that the law should be struck down, to which the court pointed out that we are not striking the law today itself. That is not something that we are looking at. We are only looking for solutions of the interregnum period. And to that also, Mr. Sibal said, then stay the law. But the kind of arguments that the petitioners have been making, the court has not expressed, it is not really agreeing to the kind of demands so far that are being made by petitioners, because they want a solution that could work in this intervening period until the government decides or completes its re-examination process of the sedition law. So some solutions there from the centre on this entire issue. Petitioners opposed to that. As of now, the bench has not assembled back in court. They are still, the three judges, including Chief Justice of India N.V. Ramana, still discussing in private on what is to be done in the matter. But in a span of about few minutes, we are expecting the bench to reassemble and then give their orders in the case.